Welcome to Lex Radio. This is the Breakfast with MyLAW. And in the studio with us, we have Efemena Iluezi-ogbaudu, legal practitioner, lecturer, and many more. Ife, introduce yourself.
Good afternoon, Kunle. Like I said, my name is Efemena. Yeah, good morning, rather. Good morning. My name is Efemena Iluezi-ogbaudu, and like Kunle has said, I'm a legal practitioner. I used to be a law teacher. I am involved in law reform. I do a lot of things, but Efemena is my name. I like to say it's my name on weekdays. On weekends, my name is Olumide. The inside joke is Olumide of Lagos, but Efemena is my name. So thank you, Kunle.
All right. Thank you, Ife. We would like you to give us an insight into your law story. I think I already explained what that means. Quite very brief, as brief as possible.
Okay, so as briefly as possible, I'll just say that I did not want to be a lawyer. I mean, I studied law in the university. Up until my 400 level, I did not want to study law at all. I wanted to be a musician, and I have 2 singles on the internet. Don't Google them. Don't. And if you do, please cut me some slack. But then I found love for law when I had my first real practical experience in a small law office in Ikeja, then at a bigger office in Ikoyi, and just seeing that I could get it done made me go back to classroom, take courses that, I sort of liked, and then grades got better, interest got better, started practicing. People say I'm good at what I do, So that's it for me. That's the story.
Yeah, that's great. So you were called to bar, and then the next year you were made an adjunct lecturer at the law school. Can you give us how did that happen? I'd like to know.
Okay, so just to rearrange the order.
Okay.
I was made a lecturer. I was offered the job before I got called to bar.
Okay.
So I was in law school. There was some. I don't want to give too many details, but there was some tests, some mock tests called snap testing. I was the highest in the course, which was corporate law practice. But then beyond being highest, there was some stuff in the questions that I did identify was wrong and gave an answer to. Give some clarity in my scripts, and I was invited to come over to the DDG's office. We had a discussion about corporate law. Incidentally, I'd written my project on corporate law and was supervised by somebody who is my role model and mentor, Dr. Olawonyese. And we had that discussion, and she just said, you know what you're talking about. And would you like to lecture? I said, oh, well, I was overwhelmed. I didn't see it coming, but I said, okay, I'll give it a shot. Why not? And got called to bar December 2017. Stepped into the class for the first time, I think January 2018. So it was fun. Yeah. So that's how that happened anyway.
That's good to know. So while you were practicing, you were also teaching. How were you able to juggle it too, knowing the
demands
of practice in Nigeria?
Well, it was not an easy time, if I'm being honest, because my work at the law firm was also very demanding. I work as track and partners, by the way, and I would see myself having to put in extra hours just to be able to compensate for my time out of work on Thursdays, because that was when I had to teach at law school. So I literally work from 8:30 a.m. till 11, sometimes till midnight. On Wednesdays before Thursdays classes, I would not have any sleep. I would basically be up till 4 a.m., sleep from 4 till 6, wake up, go into the classroom and teach. And then when I get home on Wednesday evening, I just sleep till Friday. On Thursday evening, I just sleep till Friday morning. It was very demanding, but it was also very exciting because I did find joy in teaching that class. I also found a lot of joy in doing my work, so it was fantastic for me. Plus, the rewards came. I got retained at the firm because I was still doing my NYC at the time. And the law school class ended up being the most successful to date and had the best pass rate in corporate law practice. So I'd say it was a justified experience for me. So it was worth it.
You deserve a round of applause.
I do. I do, thanks.
So seeing as you had a little background in lecturing, and you also, in the previous year, you had been a student, the question is, what is your view, or what are your views on the educational system, like using the law school as a yardstick or focusing on the law school, and possibly universities in relation to teaching law in schools? What is your view on the system that operates, also including the examination, and what operates now, what do you think would be more
appropriate?
More appropriate to be the framework that should exist. Like, what are your opinions on that?
So I'm very passionate about legal education alongside, exemplary law practice and law reform. But for legal education specifically, I would say I was lucky to experience it as a student first and as a lecturer immediately after. So it puts me in a position to actually appreciate the issue. I think that for me, what I see is that, first off, as a student, I would say that what I recognized was that, let me just say in a nutshell that I think the legal education system has to be dismantled and put together again. That's where I'll start from.
Really?
I think that, really. I think that the law school, for instance, can do a lot better. I'm not even sure if it should exist as a separate institution. That's the starting point. Or if it should be an examining body the way we have with the New York Bar. But then I would just say the issue of procedural law, which is raised at law school, which is what law school says it does, and I'm saying this being a part of law school myself, even till now, because I'm still affiliated with them. But the point is, we sort of miss out the substance in teaching at law school and even at universities. I think the Nigerian education system just encourages you to, read to pass for grades. It doesn't really impart the knowledge that you need, to carry on your practice as a legal practitioner. The goal of legal education is to prepare lawyers for practice. That is the objective. The question now is, how well has legal education in Nigeria prepared a regular lawyer for practice? I would speak for myself. I knew everything in the law school curriculum when I started my practice, but who I am now, the law school curriculum and the university curriculum contributes perhaps maybe just 1% to it, because everything I've learned has come in practice. And it's not even in learning the tricks, it's just in understanding why we do what we do. So the law schools and the universities have to understand what they do and why they do what they do. Just to go back on an experience I had this year, I was privileged to speak at the University of Lagos Lecturers Faculty of Law retreat as to the quality of standards of education delivery, something of that sort. And I did a written paper to the Dean, Professor Shenwan. I did recommend that, there has to be a synergy where we have practical sessions where they tell students the practical value of what you're learning. For instance, I suggested that in contract law class, for instance, you could teach students about common clauses in contracts. You could teach students about, indemnities, assignments and transfer, just things that will pop up in regular contract law. So I think in a nutshell that the legal education system at present is not fit for purpose, the purpose being to train lawyers for practice. I think that to make that happen, a revamp has to happen. You have to harmonize practice and the academics to ensure that people who leave law schools or leave the universities are able to look at the situation and apply their legal knowledge to solve the problem on ground. The only thing they should be lacking is experience. Apart from that, having not done it before, they should be able to confront on the first go. So that, in a nutshell, is my view. It's a very big nutshell.
No. That's an interesting thing is I was going to ask you in terms of the way we learn in the country. It's mostly fetch, pour back, retain little.
Yeah,
that's basically what it is.
Basically what we do. And I should also say, as to the grading system, because that's something that really comes up every time, is that I just think that to examine a lawyer, you need to look at what a lawyer needs before you examine a lawyer. What does a lawyer need to be a successful lawyer? If you're practicing in litigation or dispute resolution, you need advocacy skills. No law school in the country grades you based on advocacy skills. Why? To be a solicitor, you need to be composed, you need to be a clear thinker, you need to be a good drafter. Perhaps they'll say the law school curriculum currently trains you to do that. But is 1 year enough of that training and assessment? Does it really reflect your capacity to, negotiate circumstances and carry out transactions? It does not. How can a commercial lawyer leave the law school and not know what due diligence is? That's one question to ask yourself. Why should a lawyer leave the law school as a litigator or a dispute resolution and not know the function of a pleading or not know how to argue a case? So if you're going to grade students, don't grade them, the weakest grade here, the strongest grade here, or not. Just grade them on what shows the actual capacity to, practice the law. So yeah.
I was going to talk about the grading because one thing I know is like when you leave the law school, there are areas of law you might never dabble into till you die.
Correct.
And it has no effect on your success.
Correct.
Some people thrive excellently in litigation. They never get involved in corporate law, never know anything about tax, and they're good. Now, coming off the fact that that is how the space is, why are the students graded in a manner that says you must be an expert in everything when this is a profession where you can specialize? Now, in response, that was like the initial, and in response to what you said about advocacy skills and all that, I'm assuming somebody will respond to you and say that there are lawyers who never have to use their advocacy skills. They thrive. They don't need that, right? And I also think there's this portfolio stuff we do in law school where we have our logbook and stuff. Like, it's there. We're meant to use it, but I mean, a lot of times people don't even fill the logbook truthfully. People just do what they want, and it's not as much as people is because of the way the process is carried out. When you go for your portfolio, when you are sitting in front of the lecturers, that process is not as focused on as like some people just go in and they just flip. They're not looking at anything. Okay, go next person.
Right.
Now that might be because we probably have too many people in school, too many students in the law school, and few teachers to actually take time and do the portfolio assessment right would really be an extreme stress on those teachers. Probably that. And yeah, looking at all that, like, what would you say?
Okay, so I'm just going to respond. You raised two issues, the specialization point, which also dabbles into the advocacy point I made. What I think is a fix to both issues is that, and this is just me thinking off my head, I think that the idea that law school tends to present itself as a degree is wrong. So, I have nothing against people who get first-class degrees at law school or who do it at law school, which is fantastic, but it is a professional practice degree. So it should say you're qualified to become a lawyer or you're not qualified to become a lawyer, then show your strengths. So when I say advocacy skills and due diligence and transaction skills, if I pass the bar exams, for instance, then the law firm who's hiring me should have the benefit of doubt to see that. Should have the benefit of seeing that this person that has put his CV before you, his strength is in advocacy. Her strength is in transactions. It should reflect that. And when it reflects that, you don't have the first class 2-1 thing hanging over your head. Yeah. They'll then ask you, what role do you want to apply for? If your strength in advocacy, why are you coming to transactions? And if your strength in advocacy are showing on your law school degree, then they know that this particular person is a good advocate or would make a good advocate. At least we can assume that, Yeah. So I think that, not giving a blanket grading, but giving a grading that says you passed the bar, these are the strengths, these are the weaknesses, helps. And the breakdown does do this, because for my breakdown, I had it being criminal litigation. I have never stepped into a criminal court in my life. I had all A's in other courses, and maybe it does show to some extent my strength, because I work now in a commercial firm that doesn't do any criminal cases. So maybe that shows my strengths. But then if we take away the first class toga, the rest of the breakdown will perhaps present, a clearer picture of what the person's strengths are. And if you make it clearer as to advocacy, transactions, things that are more relatable to practice, that would help. Then to the second point you made, the portfolio assessment, what I think is that, and as you were speaking, it just came to mind that portfolio assessment is actually the most effective method in the Nigerian law school system for determining how competent a student is. It's just that, and I wonder why. Whenever a process is seemingly subjective, we tend to not take it as seriously in Nigeria. I don't know if it's the culture. Nobody wants to fail anybody. Nobody wants to be the one that's caused somebody's downfall. If they put marks to the portfolio assessment and say you must get a minimum 60% before you can sit for the bar exams, that would work, because anybody who comes to the portfolio assessment committee would understand what went on in his courts and in his chambers.
Yes.
Now, based on the understanding they display, you would then know if they are competent to sit for the bar exams or not. Because why should a law student who wants to be called a lawyer go to a chamber and a court and not understand what's going on? That's hilarious. It's upsetting.
Yeah.
So we send you, you're supposed to be fit and proper, we send you to a court and to a chamber, you come back, I don't know what went on. That means you're not ready to be called to bar. That's what I think, So I think if we take that process more seriously, students would take it more seriously and would have better graduates from the law school. So I think that
if the process adds more hold more score than the actual written test.
It does. Maybe not even hold more score. It just serves as a filter to say if you don't get 60% in portfolio assessment, you can progress to writing the bar exams. That's my take.
That makes sense. If you were telling us how you never really wanted to practice, and
correct,
up until like your 4th year,
correct,
had an interest in practice, and then later you found the passion, and then you found the space and all that. Can you tell us how practice is now for you beyond being an adjunct lecturer? How's practice like? What do you have to say about how the journey has been?
I'll say it's been an interesting one for me, and it has come in many dimensions. So far, I've been very fortunate. I say fortunate because I believe that all the things, the opportunities I've taken, I've been very fortunate to be involved in, not just law practice, but like law teaching, as you mentioned, and law reform as well. For practice, we've spoken to law teaching already, but for practice has been fantastic for me. I've been able to do a couple things that I didn't think I'd do as of now. Positive things, of course. I was recently shortlisted, finalist in the Africa Legal Awards Most Promising Newcomer Private Practice category.
Wow.
So that for me was, it's good to be recognized. It's an African award, being top 10. Being top 10 in Africa was...
Congratulations.
Thank you. It was very big for me. And it's still my pin tweet till today. Apart from that, what I see myself as, and what I see when I look at my practices, that I see myself, trying to be the example for younger lawyers, and teenagers who want to become lawyers in future. You know how you're young, you see Davido, you see Whiskey, that's what the youth see now. I want you to look up and say, there's somebody who's a lawyer who's doing big things who I want to be like.
Who's young,
exactly. That's exactly what I want to portray, what I intend to portray, what I do. That's why I do things I do, and for me, I do this because I don't see many examples of lawyers these days. Even the ones who are, outstanding are not publicly recognized. Very few Nigerians know the best legal practitioners in the country. They probably just know Femi Falana, who's brilliant, but we need to have more examples. Even beyond this, not many lawyers are examples to be followed.
Why did you say?
Well,
the reason for that.
Yeah, so one of the things I take strong views on, I have many strong views, is the rank of Senior Advocate of Nigeria. Okay. When you hear Senior Advocate of Nigeria, you have in mind, a legal practitioner who is distinguished in competence and in character.
Yeah.
I have been in courts where I've seen senior advocates, argue ridiculous points of law and fact. That is not. You may be a senior advocate in rank, but in competence, I beg to differ. On character, I know several senior advocates of Nigeria who are standing trial for criminal offences. It should not be so. And I don't know if I'd mentioned before in one of our casual conversations how, in England, there was an issue with Lord Denning being standing trial for something. And he said to himself, I can't be the master of rules and stand trial. God forbid, and he stepped down. That's not the way it happens in Nigeria. People do not, out of honor or respect the profession or deference, treat the profession as it should be treated. You cannot, for instance, be a senior advocate or be a judge or, and be indicted on some level. It doesn't inspire confidence. It does not. And as a profession that renders service to the public, how the public views us is very important. Back in the days, being a lawyer was a big deal. Now, nobody cares.
Well, I think people still care. But probably maybe the prestige around the profession.
Well, I would just say that
not as it once was.
Some guy on Twitter, had a debate with me over the Kama 2020, and he thought he had a view and was tagging me to Falano's tweet, telling me, see what Falano said. He's agreeing with me. Who are you to disagree with me? Of course, I'm not going to tell him I was a lecturer in Nigerian Law School of Corporate Law Practice, so that I've studied Kama back to back. But, when a non-lawyer starts to debate the law with a lawyer, then he tells you what they think about our profession.
Well, this is like those situations where you feel something is wrong with you, and then you go to WebMD and you feel something, and then you argue with your doctor. This is just one of those things.
Well, if you're about to die,
a reflection of
if you're about to die, and a specialist doctor tells you you're about to die, you will not argue WebMD with him. If you think it's that serious, then you wouldn't argue WebMD with him. And by the way, even besides the point, the public tends to listen more to public analysts and listen to lawyers now. They think all lawyers are liars. They think all senior advocates are thieves. The other day, two governors in this country have gifted publicly cars and houses to judges, and the public is saying, what about our roads? It's for everybody to chop, the judiciary as well. This is the public perception of our profession.
Okay, coming off what you said about the silks, my question is, to get to that stage, there are certain criteria you must fulfill.
Correct.
Are you saying those criteria aren't sufficient enough for what that title should stand for? There should be more to, you must have a case or finish the case in Supreme Court. There has to be more than that.
Yeah.
It's something that was good to character. And I'm saying this because it's something I strongly believe.
Okay.
That's part of the problem of governance, maybe worldwide, Nigeria, but using Nigeria as an example. You see, people should be held to certain standards when they occupy certain positions.
Correct.
Right? If you're going to study to be a pilot, I think if you're the type who is clumsy and aloof and you're the type to lack focus, that shouldn't be the course
the path for you.
Understand? Now, if we have people, the area I feel most about this is the legislature. Do you understand? These people who are supposed to make our laws. In fact, I wouldn't mind if they have to go for a 1 year course, the way people go to law school, because it's such a very important part of the progression of the country.
Crucial.
So you must have certain trainings. We can't have the people who write our laws jumping over. Do you understand? There has to be some certain level of understanding. Coming off that idea, I can understand what you're talking about the sales and stuff, but I also understand that, and I know there are criteria
for that.
So are you saying the criteria aren't enough? What would you rather have? Because not every criteria can really filter our characters.
Correct.
Yeah.
Okay, so I'm going to try and address, because in answering the question, I'm going to address 2 points. The first is rank of silk. Interestingly, a new shortlist was published very recently. I think it was a couple of days ago. I'm just listing, people who have been shortlisted to be senior advocates, considered for the rank of silk. And I just thought to myself, I see these names, I don't know these people. I'm a regular young lawyer who's going to be looking up to these people once they attain the rank of silk. I think that the rank of silk is a rank of leadership.
Yeah.
The rank does not confer it, the rank recognizes it. So in essence, the rank says, I see you as a leader of the bar in competence and character, and I will make you silk. So in terms of the criteria on ground, I think the criteria is very quantitative, not qualitative. To say somebody's a leader of the bar, the person has to show exemplary conduct and exemplary competence. Ask them, of the 14 or 15 or so cases you've done, in which of those cases can you show us that you conducted yourself or that you showed exemplary competence? In your immediate and surrounding environment, can the people there say you are a person of exemplary character? Those are the 2 questions to ask yourselves. The body of benchers, will probably, the LPPC will probably, judge you based on your competence, based on the cases you bring before them. I'll probably decide. I don't know how they decide. But I don't know many people who have contributed to law in the past.
Okay, so you would
how
also
many
be
years?
saying impact of what you did.
So I would ask you, you
impact?
presented this case to us, that you won this case at the Supreme Court. What has this case done for us in Nigeria and our law and our jurisprudence? How did you assist the judge in reaching this conclusion? I saw a case in England where they argued, I can't remember this case, but there was an argument as regards damages across 2 contracts. Whether damages on one contract could be inferred from another contract. It was a very substantive argument. If I remember the case, I'll forward it to you guys.
No problem.
Those are substantive arguments. Whoever wins or loses that case contributes to the jurisprudence. In Nigeria, at the Supreme Court level, you still have arguments and authorities on stamp and seal, whether or not to sign a writ of summons. If you present that case to me and I'm sitting on the LPPC, I would chase you out with your silk, because the fact that you're bringing that case to me, for one, shows that you don't know what you are doing. 2, it shows that you have nothing else to offer. People have argued great cases. There are cases that changed law for good, you know. Even people that argue jurisdiction, look at Madukolu. Whoever argued Madukolu till date has laid a mark. You know, so in terms of the criteria, just to keep it short and simple, there has to be a merit-based process. We have to be sure that they are both leaders in character and competence. I'd recommend, I'm just thinking off the top of my head, when they publish the shortlist, perhaps they should go back to their branches. The branches should, you know, make some comments about them, not by the chairman, but by the general branch, maybe general vote. If you don't get 7% of your branch, you go away, you know. And they should make sure that they do a pitch, proper pitch. In my portfolio, I have this 12, 15 cases. These are how these cases affect, you know, law and, you know, and our practice. You know, let it be public. Let people decide. Let people choose their leaders. If somebody I never knew from Adam comes before me and tells me I have changed the law in 1, 2, 3, 4, 5 ways, I'll be impressed. And I'll vote him to be Silk. That's how I see it, you know. So I think the criteria has to be more merit-based, more qualitative than quantitative. Now, any Tom, Dick and Harry can have 16 cases and apply for Silk. Yeah. It should not be in that way. Then on the point I want to make, which also clarifies something I said before, you know, the problem with the legislature, this is by the way, it's not that common men cannot make laws. It's that they don't understand, they don't seem to understand their function and their importance to us. Yeah. And just to dribble back on what I said before, it's not like a non-lawyer cannot provide perspective on a law.
Sure.
It's just that if you are debating the effects of a law or the validity of a law, then the question of validity is best resolved by somebody who knows how laws work. But then it doesn't mean that you can't take, you know, an opposing view from a non-lawyer. It just means that when it comes to some particular questions of law, a lawyer is in the best position to answer it. And that's why I said, if a non-lawyer thinks that on a question of law, a strict question of law, they know more than you, then it means that they're not confident in what your system is producing. So yeah.
Well, I've heard what you said, and do you not think with the there are 2 areas I'm going to address.
Okay.
One is the type of cases that you speak about getting to the Supreme Court. And I think I've heard something recently that that's not just about the Silks, it's about our system generally. Cases like that should not be going that far. They should probably be ending at the High Court.
Correct.
Right? So that's one.
Correct.
2, if we tend to make everything political in the country, and I even think possibly, I don't like speaking too much on issues I'm not quite grounded in, but possibly I would assume even the process for becoming a son and aspiring to the Silk, you know, definitely there will be politics in play. I also think now that we've spoken about it, and like basically people who want to reach that place mostly just aspire to fulfill the criteria.
Exactly.
Right? Not embody what the criteria is trying to get.
Exactly.
Of type of mental of people that should get.
Exactly.
But I also think like if it became the type of thing where you're like, oh, your brand should vote, just make it. Don't you think that makes it more political?
Correct. You know.
Right.
Yeah. There's that fear for real. You know, because people are going to be going to lobby.
Exactly.
People are going to vote because, you know, want our guy to become Silk, you know. But I do feel that, and this is why I talked about the leadership matrix. A Silk is the leader of a bar. If the bar chooses a Mr. Tom, a Mr. Dick, a Mr. Harry to be its leader of the bar by any process, then the bar has chosen their leader. Why I speak for the involvement of the branches, maybe not just one branch, maybe they do 6 branches across the country, and out of 6, 7% of 4 must speak here. But the point is, why I speak to that effect is that let the branches with their hands recognize their Silks. In the last NBA election, we did note that it was a war between non-Silks and Silks because the lawyers currently do not recognize senior advocates of Nigeria as their leaders. If they did by some measure, then probably will not be where we are. But this is just by the way. I completely agree with your point that people now just strive to fulfill the requirements, the quantitative requirements. I'd also say that it's ridiculous because now the rank of Silk is essentially just a billing element. So I'm a regular lawyer, I charge you 50 million. I'm now Silk, I charge you 100 million. That's why many people do it. Why do you want to be Silk when you're not Silk material? You should shy away from it because
I mean, you have the answer, right? So I can build double.
Yeah, I work for somebody I consider exemplary, and he does say to me that he considers the rank of silk a burden, and that is how people should see it. You made a point, which I can't really recall. I'm not sure I can recall it. Okay, just
no.
Yes, you made a point just before, but I can't recall it. But you can go on.
That they do it so they could double the.
No, not that. When you spoke the first time. But yeah, go on.
Okay. So you work on the justice reform project, or you are involved in the justice reform project. Can you just give us like a brief insight into what that is all about?
Yeah, it's a big part of what I do, and you see. Yes, I remember what you said.
Okay.
It ties into this. So the Just Reform Project is a not-for-profit organization. It was set up by 20 advocates of Nigeria, 20 of whom I respect and regard. So we have 20.
Still respectable.
We have 20, yes. Then out of those 20, more senior advocates of Nigeria joined them.
Okay.
I respect those people as well. Okay. So I endorse them. And then after those senior advocates of Nigeria,
someone somewhere is going to watch this and be like, who are you to endorse anybody?
Well, if somebody asks you if you can tie a shoelace, you tell them yes, I can tie my shoelace. If somebody asks me if I can endorse them, I tell them yes, I can endorse them because of who I am. If you don't know who I am, you should Google me, but that's by the way.
Go on.
So the point is, basically, from 20 silks to more silks, we got lawyers, we got businessmen, we got people in society. It's now a body of Nigerians who want a better justice system.
Yeah.
And what they're basically doing is carrying out projects, putting in place policies to make sure that things function in justice system. It's a very huge task. It's very big because it takes a very broad view, but so far so good. Baby steps, but effective steps as well. And I'll give an example based on what you said. This is what I was trying to remember. You did mention that you don't think that those kind of cases should get to the Supreme Court. Talked about writ of someone's sign, stamp, and seal. Correct. So recently, the Senate Committee on Judiciary published a call for memorandum, saying if you want to amend the Constitution, submit your proposals. And one of the proposals we made as Just Reform Project, which is one of the things we've done, is to amend the right of appeal. This is something I was personally involved in. And the idea is, one of the simple things we try to do is to say, on matters of procedure, questions arising out of the civil procedure rules, the high courts of whatever state, the trial court, should be the final courts. So on issues like signing writ of summons would end at the trial court. Issues like service of processes will end at the trial court. The only time you can go beyond the trial court, because we must recognize that there are instances where it could cause a problem, is when you allege that it can occasion a miscarriage of justice, in which case you should then seek leave of the Court of Appeal to have your appeal heard. But in that case, because you're seeking leave, you can no longer delay cases. Because what usually happens is that once you appeal, you file a motion for stay of proceedings, and you stay the proceedings until you decide whether or not you can use stamp and stay with the Supreme Court and come back. That's plus 8 years.
I imagine.
So we've done that. Another project we've done, which I think, if I do say so myself, is commendable, was the advocacy we put into the adoption of remote hearing. So, quick narration: when COVID pandemic broke out, we wrote to the NBA president saying, "See, there's a pandemic, courts cannot close. There's adopt remote hearings." We wrote to the CJN saying, "There's a pandemic, courts cannot close, adopt remote hearings." A couple of days, maybe a week after, the president, released a communique saying, "I'm adopting remote hearings. I'm giving palliatives," which is something we also suggested as well. And it was good to see that happen. Then fast forward months after, the NJC says remote hearings that's what we'll do. Courts across Nigeria are passing practices for remote hearings, and everybody's saying remote hearings. And we're happy to see this happen based on our prompt. And also, we noticed that there was a problem with implementation, and we said, okay, we're going to show people that it's doable. And then we conducted the first full virtual hearing in collaboration with Lagos State Judiciary. It's all on YouTube. Just from project. First full mock remote hearing. It was presided over by Honorable Justice Olushola Williams, retired, and Honorable Justice Ikpaye, currently at the High Court of Lagos State. Had real life lawyers, was a real life case, and I was registrar of that proceedings, and it was very good. I think the final thing I'll say we have done is that, and this is a very big one because it's very important, but it's important that it was done as well. Sometime in May, the NJC announced a list of maybe 50 people who were to be nominated for appointment to the High Court of the FCT. And there was an outrage by the public saying these people should not be appointed. They know somebody, they're not qualified, And then the JRP said, okay, we know what, we'll look through, we'll examine ourselves objectively and come to a conclusion. And we found that about 21 of them were not actually qualified by the standards that the NGC set down.
Wow.
And JRP commenced an action saying, you know what, declare that these people are not qualified to become judges. Fortunately, the president, in forwarding his list of names of appointees, excluded 20 of the 21. Only one of those people got appointed. So, for us, for me personally, it seems like a win to me because,
that's impact.
Yes, impact. So it's baby steps, but this works. So essentially, the goal is to reform the society project by project. Yeah.
Yeah. Before you go, shortly, it's going to be two-pronged question.
Okay.
This idea of the common man, oppressed, powerless, almost an inevitable offender or victim to the existing economic imbalance, poverty, that automatically makes him an inevitable scapegoat, right? It's almost like a paradox in line with the fact that when it comes to white-collar offenses, there's almost a sycophantic laxity to the manner in which those cases are taken.
Handled.
Handled. What's your opinion in line with that? In seeming linking that to the supposed, corruption of the judiciary in line with the fact that a lot of these things are like. What are your opinions? Quick tidbits on what you think can be done in.
So
side seems like such a big problem.
Yeah, if I understand you correctly, you're saying that the poor, the oppressed, the vulnerable are by the society standards pushed to crime.
Yeah.
Lack of a mentor, so they're forced to go into crime. And once they go into crime, the system comes down on them and punishes them. Meanwhile, on the other hand, the rich man who commits a bigger crime is left alone. Yeah. First of all, it's not a problem of law. It's a problem of people. Leaders don't have the moral courage. They don't have the skin.
Most of the time, these white-collar offenses are mostly by governmental.
Don't have the skin. I know there's a governor who's caught on camera packing dollars. There's another one who's an ex-governor, had 2 billion vans, driving to his house during the elections. And these are prima facie evidence of a money laundering, but nobody's going to act on it. It's the people. Until Nigeria as a people, this is outside law completely, decides that we want things done differently, perhaps by revolution, perhaps by election, perhaps by, some other means of strife and struggle, nothing's going to change. The laws can be picture perfect, but if the government chooses to disregard the law and courts as they've done, nothing's going to change. And the common man will continue to hope in a judiciary that favors him. The day the judiciary stops to favor him, he has nobody to run to. So I understand that makes sense, because the law was made for the people were made for the law, and if the people determine the people that would be in judiciary, executive, exactly,
legislature. Thank you for that. Before we go, seeing just the concept of breakfast of MyLAW, trying to get to these personalities who seem to be doing a lot of these interesting things in this space. You understand? We need to show that practice is beyond simply, probably talking to the person who is in like year 3 and it's like, I don't want to do this. Probably has a music career that he wants to pursue, that he might just abandon later, and going along with what you do now. Like, what advice do you have? Because obviously your journey is still just starting. You understand?
Yep. And
it's also important to have perspective from the person who's just starting out, as opposed to the person who has gone so far. So, like, what do you think? Tidbit you can give to help them with their journey?
Okay, thanks. So I'll just say first of all that if you have a music career in school now and you're confused about doing law, I'll tell you that law is good, because law is a stepping stone to many things. A lawyer who's a musician, a lawyer who's a comedian, a lawyer who's a presenter, Ibuka, case in point, is very likely to do well. So go for it. If you want to practice law, it's a lot of hard work. It's a lot of humility. It's a lot of learning. You have to keep your head on the ground, I tell people that I'm only proud for the press. If you see me, I'm very humble normally. I ask questions. I say I don't know. I wait for people to tell me what to do, And in my early years, I've learned a lot. But I mean, ultimately, I've identified 3 factors I think everybody should have, not just lawyers.
Yeah.
And I will just run over them. The first one is focus. You need to know what you want. And when you know what you want, you need to focus on it from start to finish. You need to not take your eyes off the ball. There will be distractions, stay focused.
Yeah.
The second is determination, resilience. In your chase for whatever you want, you can't stop. It's not enough to keep your eyes on it. You must also keep running towards it. It's super important, and there will be obstacles. You will fail, but you just have to get up and keep running. And the final one is to believe in yourself, and believe in something much greater than you. I tell people I'm not afraid to say I'm a Christian. I love God, and I depend on Him for most things I do. In fact, for all things I do. So just 3 things in a nutshell for me do it for me. And if I will add anything else, I would just say that there's no substitute for hard work. Even in my experience with young lawyers,
recently our generation has this new tagline where it goes, "Don't work hard, work smart."
Nah, even working smart is working hard,
right?
Because it just means that you know how to manage your effort and know where to put it.
I get the idea of that statement, but it feels like it comes from a sense of take shortcuts. Like I feel like that's what it usually applies towards, because like work smart is there are ways you can do it. Well,
fair enough.
But
I mean, it's not work smart, still work hard, and there's no substitute for hard work. You must put your head down and do the work. And just to highlight, to illustrate this, I've been marking a couple essays for the Professor JLS essay competition. And what I did notice is that people just don't apply themselves. The question that says evaluate taxation in digital space, something of that sort. The question has some keywords. You have to look into those questions. You have to answer the question. You have to put yourself into the work. If you don't do that, I think you're going to do a half-baked job and get a ceremony train on your behalf. It's not going to happen.
Yeah.
So you have to do the work. So I just want to say, this is it for me.
Yeah.
Thanks for having me.
Thank you very much for coming. It was,
and I hope this helps.
Nice to have you. We had conversations that I think are relevant to what's
Thank
going
you
on
very
in the
much.
legal space, and that's what this is about.
Thank you very much
for coming.